Yes, good evening to everybody, the students of Advanced Private International Law. And this is my second absentia because I tried to contact the students, but I could not get them. I tried my level best, but no one is approaching me. But at the last, I decided to make it out. At least they could understand what is the conflict of laws, in other words, advanced private international law in another way as per our syllabus wordings are concerned. So without wasting the time, otherwise I would have to ask one of the students to read so that I would have to give the explanation to that one. So the Code of Justice of the European Union. So when you say the conflict of laws, yes, there the UK role is also there, and most of the European Code of Justice of the European Union, and whose headquarters is Luxembourg. CORNISCHONG, Cornichon. It is a project for the unification or harmonization of the laws on a wider, in some cases worldwide, basis have been pursued since the middle of the 19th century, when the Italian Minister of Justice, Pasquale Stanislao Mancini, sought to convene a conference for the harmonization of private international law. So he made his efforts to see that there would be harmonization in the private international law among the countries in the world. And similar efforts by the Dutch jurist Tobias Michael Carroll Usser proved successful in 1893 with the founding of the Hague Conference on the Private International Law. In 1904, Japan became the first non-European state to participate in the Hague Conference. Over the years, the Hague Conference has produced many conventions, some of which have enjoyed a notable success, especially in the private international law, such as the conventions on the civil aspects of the international child abduction, 1980, and the conventions on the yes, 1980, where we are studying here. Of course, yes, let me repeat. Notable conventions are made, such as the conventions on the civil aspects of the international child abduction, 1980, and the conventions on the service abroad of judicial and extrajudicial document in civil and commercial matters, 1965. The International Institute for the Unification of the Private, that is UNIDRIPE, established in Rome, 1926, sponsors projects for the unification of substantial law. Example includes the clearly efforts with the international sales law and the more recent drafting of the UNIDRIPE Principles of the International Commercial Contract, 2004. In Latin America, Mercosur, also known as the Common Market of the South, whose members include Argentina, Brazil, Paraguay, and Uruguay. led the harmonization of the important aspect of the international business law, particularly in the area of the landmark, investments, and competitive antitrust law. The Andean Community, within parentheses, Comunidad Andina CAN, both everything CAN capital, has promoted the harmonization of the copyright and patent law between its member countries of the Bolivia, Colombia, Ecuador, and Peru. So, see also the intellectual property law. So, it also covers some of the points. Another unifying force of growing importance in international business practice and the custom, the so-called lex mercatoria, that is the law of merchant, to which courts, arbitration tribunals, and parties increasingly refer in the decisions and the commercial dealings. There is nothing but law of merchant, what method, what rule, what the thing should be followed in the place. Then we'll see the common principles. Although few uniform international conflict rules exist, there are a number of common principles are recognized to varying extent throughout the world. The ancient international principle of comity, which like the biblical golden rule, postulates and even sovereign states should extend countries and privileges to each other. Explain why one country would give the effect to the law of the another. When you see the comity, it is like the give respect and take respect. Suppose if you have any person, it is for the a broad example of the Chinese. Let us go to even one country, goes to the another country. At that instance, they will give the equal respect to the earlier country. But the later on, the another country goes to the first country. After some time, the equal treatment will be given to the country. That is called principle of comity, and there is a biblical golden rule. Give respect and take respect. A formal requirement of the reciprocity would actually limit the extent of these courtesies and privileges to those that are the state is willing to extend. Party autonomy, the freedom of parties to decide the court shall hear their case and what law shall govern it. Of course, the court decision, it is recognized in the most countries. Those of the Latin American being the notable exceptions. Legal system have established a different criteria for the selections of one's country's law or the another application to a particular case or problem. Suppose if you will be participating in my virtual class, then definitely I would ask you the question, what is biblical golden rule? But you are not there, and hence I frame the question, then I give the answer. Let us see at least the next class, so that your participation will be there, and where you participate, and I ask the question and I give the reply. If you don't give the reply, then you can just say the pass on, so that I will come to your rescue. So coming back, legal system have established a different criteria for the selection of one's country's law over the another for the application to a particular case or problem. There, however, some widely shared principles are there. For questions of family law, inheritance, limited type of the cases, even liability in tort, legal system will consider the nationality or alternatively domicile or habitual residence of a person. So, connecting to the family law, inheritance, and even the thought and the legal system, it is mostly based on the nationality or the domicile of a person. For commercial transaction, the transaction's closest connection to a legal system may be emphasized over a traditional connecting factor such where the transaction was concluded. Factors determining a close connection to a particular state and its law may be the place of business or the principal residence of the party that is affect the performance in question. The language used by the parties in their negotiations and contract formation, the currency and the modalities of payment specified, the other factors that are not as incidental as the place of the contracting may be. Exemplification, e.g., when a contract is concluded in a hotel or other meeting place because the both the parties in transit, or cases involving legal persons, corporations. Many countries, particularly those of the common law tradition, refer to the law of the state where the law of the state where the entities is incorporated. But others, especially those employing in a civil law principles, refers to the law of the corporate seat, defined as the place of the central management and decision making. Among the later countries, especially in the EU, there is now a trend to change the place of incorporation rules. So it depends upon if the corporate are sitting in the transit in any hotel in the New York and signing a contract. It doesn't mean the contract is signed in the New York because their headquarters are in different places. That will be counted. So let us see what other aspects we will going to cover. Especially, I repeat, especially with the respect to the commercial transaction, that is the contracts. Modern, especially the quality here, the modern conflict of law emphasizes flexibility. This quality is evident. This quality is evident in the Article 4 of the Rome Convention. I repeat, this quality is evident in Article 4 of the Rome Convention. What quality? With respect to the commercial transaction, that is a contract, modern conflict of law emphasizes flexibility. They need the flexibility would be there and where the case would be filed. So the quality is evident in Article 4 of the Rome Convention, which first establishes in general principle that the applicable law should be that whose the contract has been closest connection. So that was the principle which is adapted over there. That is the closest connection. Although the article provides some presumptions regarding the law that might be it concluded by making it possible for the court to correct the result. If the court found that exceptionally another law was more closely connected to the contract as to one of its issue, then it would apply that law. So which law to be applied? It is the discretion of the court to see which is the closest connection with the transaction. Then the convention's successors, the Rome I regulation, replaces the presumption with a specific rule for the number of contract types and retains the general reference to the most closely connected law for all other countries. Of course, see below the choice of law rules are concerned. Now let us see the jurisdiction. As stated above, the first question is in an international case of potentially involved conflict of laws. Problem in which the case has jurisdiction to adjudicate the matter. Although the plaintiffs decide where to use, the courts in which the locations may not have a jurisdiction, or they may have jurisdiction but willing to exercise it for a reason of forum non-convenience, in the Latin inconvenient forum, as happened in some of the common law countries. Overall, what I want to say regarding the jurisdiction is concerned, then the prime talk or the wish of the plaintiff will be taken into consideration, because in which area and he is comfortable to file the case, that is a forum shopping. So generally that the court will not deny to that one. Let us see the rationale behind the choice of jurisdiction. There are several factors that affect the plaintiff decision for the way to file a case. One is convenience. Here let me give a break to ask you. Suppose a murder was committed in Monza. Can you file a case in Dar es Salaam? Answer, no. Reason is, Monza police station is having jurisdiction to entertain such a case. So a complaint would be filed to the respective police station where the incident murder happened, under where this come under which police, as the police station A, B, C, or police station 1, 2, B, whatever it may be there. For example, a plaintiff is likely to want to sue in a jurisdiction that is reasonably close to his home, particularly because witnesses and evidences are more readily available there. The legal question also are important. The plaintiff may be more likely to file a suit in a jurisdiction that will afford him procedural and other advantages, and where the defendant has assets with which to satisfy an ultimate judgment. At that instance, one should have to think it. But anyway, the court, what they did, they will see that the judgment will be implemented. Because in any case, the court will not dissatisfy the plaintiff who goes to the court for the justice. That is the primary aim. Examples of likely procedural or substantial advantages include the possibility of the jury determination of damages in a tort case, the availability of the punitive damages, the case of obtaining the territorial discovery of evidence commonly used in the United States, the possibility of suing on only a part of one's claim to determine the likelihood of success before committing resource to a suit on the entire claim, and advantages exploiting the variation in the liability of these standards. However, the place of suit is not entirely up to the plaintiff. The chosen court must have the power to entertain the case jurisdiction to the adjudicate. The jurisdictional grant will usually be defined by the statute. In addition, the exercise of the jurisdictions may also be limited within parentheses as a check on the statutory grant and the judicial exercise of it. By constitutional provisions or persuasive principle of law in the United States, this is the function of the due process clause of the 14th Amendment of the Constitution. Of course, there is a due process clause is there, the amendment is made, and according to it, they follow that law. Now, let us see how we have to follow it here. In common law countries, provision of law or the court decision-making practice may limit the access of the jurisdiction to adjudicate of any number of reasons, including the need to prevent local courts from becoming clogged with the litigations with which they have no concern, or litigation between the foreigner and concerning the claim arose abroad, especially when seems likely that courts of the forum States have chosen only a means of gaining the procedural or substantial advantages not available to the plaintiff in his home country. In a home country's court, so-called forum shopping, especially in the United States, courts may consider themselves to be a forum non-convenience. In these circumstances and dismiss the action. Of course, I told you that it depends upon the court whether the forum convenience is used over there and which will give the justice to the party. The court will take the decision. This occurs in the Piper aircraft versus Reno. I repeat, this is occurred in the Piper aircraft versus Reno. A suit filed in the United States on behalf of Scottish parties and whose relatives were killed in airplane crash. The flight originated in Scotland and was scheduled to end there. The aircraft was owned by the British entity. The pilot was Scottish and all other relatives are Scottish. Only the defendant, the airplane manufacturer Piper, and the propeller manufacturer had a connection to the United States. Because of the plaintiffs sought a remedy that were not available, at least not to the extent desired. Under Scottish law, they decided to bring a suit in the United States, making this clear case of the forum shopping. See, when all the parties are the Scottish, but still the plane crashes happen, and that is a plane, of course, it is a manufactured with a Piper, and who is a United States, and the propeller manufacturer also United States. But the rest of the all members are Scottish people. But still, to give the justice, even for the few people, a minority, there may be deviation of the cause of the deviation of the law which can be used, as a basis to decide. So here, they decided to bring a suit in the United States, making this a clear case of foreign shopping. So it is a give the clear case of the foreign shopping in the case which we just read it. American courts may dismiss for forum non-convenience when the exercise of jurisdiction could be unduly burdensome for the defendant. In many cases, dismissal protects a foreign defendant as much as it protects the local courts from unfair burdens of foreign litigation. Courts likewise will not uncertain against concerning title to real property located in another country, while their judgments would bind the parties before them. The power to deal with the property itself with effect as and against the potential claimant belongs solely to the country of the location, that is the situs, where the property is situated. Civil law countries generally don't dismiss the action for the reason for forum non-convenience. Of course, civil law countries, they say that they want to give the priority to the plaintiff. The plaintiff should not run from pillar to post, forgetting the justice. The European Court of Justice, and whose headquartered in Luxembourg, has held expressly that the allocation of jurisdiction by the EU law, namely Brussels I regulation, is binding on the national courts. As an exception, the Brussels II regulations permits dismissal or the transfer of forum non-convenience, reason in child custody is concerned. Yes, they consider over there. Each country determines the jurisdiction of its court to entertain a civil lawsuit. In federal countries or unitary system with a strong traditions or regional or the provincial jurisdiction, that is the United States, United Kingdom, Canada, and Switzerland becomes a necessary becomes a necessary yes becomes a necessary determine was the jurisdictional civil law system in some countries determine was the jurisdictional civil suit may be brought. Some countries, Germany and Australia, are the central law governs, while the constituent states may determine the jurisdictions of their court themselves. The United States, although state court jurisdiction in a matter of such law in the United States federal constitutional law, particularly the 14th Amendment due process. This earlier also we discussed the due process there in the American Constitution. Equal protection and the privilege and immunities clauses limit the assertion of the state jurisdiction. Most countries allow the parties to agree to the jurisdiction of a court. I repeat, most countries allow the parties to agree to the jurisdiction of the countries. Yes. Consent may take the form of an express agreement in the initial business contract or at the time the dispute arises. Alternatively, consent may be the result of the conduct. The plaintiff consent appear from the filing of an action. The defendant's consent may be presumed when rather than objecting the court's jurisdiction. The defendant confesses judgment and appear and begins to litigate the controversy. Even when both parties consent to the court jurisdiction, the court in a common law country may still decline to hear the case. I don't know why it is declined to hear the case. When both the parties consent to the court's jurisdiction, the court in common law countries may still decline to hear the case. For example, when neither of the parties nor the controversy has connection to the country, when there is no connection to the country in which the court is located, at that instance, they will not entertain it. Yes. In most cases, however, court jurisdiction is not an issue unless until the defendant objects to it. Suppose if the defendant does not object to it, then plaintiff will continue the case in the same forum shopping. Difference between the civil law and common law countries in the absence of the choice by the parties. Traditionally, civil law and the common law countries have followed the different approaches in determining which court has a jurisdiction in a civil action when the parties have not agreed to on or submitted to the forum. Civil law countries start from the premise that there is one principal place where a suit can be filed, the domicile of an individual, on the seat of the legal person such as in a corporation, that is for the corporate. In addition to these general bases of the jurisdiction, a suit ordinarily may be brought in the courts of the place where the suit has special connection and where a tort was committed and where its effects were felt, where the alleged breach of the contract occurred, or if the title to real property is involved, where the property is located, specific jurisdiction. Increasingly, countries have limited the exercise of the jurisdiction and have prohibited parties from varying those limitations and agreements for the protection of the weaker parties, such as employees and consumers. Such a pattern has emerged, for example, in the procedure of the EU.